Hello and thanks for checking out the first video for digitpros.com. My name is John Birchall. I'm a non-practicing barrister and I've got a background in legal training and trading lawyers. And I'm going to make some comments for people who might be running a discussion board or a community site who are concerned that they might be sued. And that's a real problem. What can you do to protect yourself? I have to give my own disclaimer here. I'm going to talk about disclaimers. This is legal information, it's not advice. You shouldn't rely on it. If you need advice, you need to consult a lawyer qualified to practice in your own jurisdiction. The Mumsnet case was quite unpleasant because on a discussion board run by some mums about childcare, a specialist in the subject was defamed, and she sued Mumsnet. And the outcome, in a sense, was never really known because it didn't go to court. It was settled, but it was reported in the newspapers they had to pay her a lot of money. And clearly that's the kind of thing you need to be concerned about. I thought I'd look a little bit at the way Facebook go about things, because you can be sure their lawyers have done a good job, although it's a little bit unclear, as we shall see, what the effect of their document is. When you sign up for Facebook, you'll see on the right hand of the screen the sign up page. There's no "I accept your terms and conditions," and you can be sure the Facebook lawyers are aware of this, and yet they do have an agreement which they call a statement of rights. Is it an agreement? They call it an agreement in paragraph 18, and it goes through the kind of things that they are aware you need to be concerned about. So right at the top we start with privacy. Is the privacy of the people who sign up going to be protected? And they have a privacy policy which you might well want to have on your site. Sharing your content, that really deals with who owns the copyright to things that members of the discussion board or the community site might write or post, and what you can do as a discussion board owner with that. Safety, well, clearly there are issues here. People might be posting viruses, people might be making physical threats and so on. And if you're running a site where people are communicating, then you need to be somehow supervising for that kind of risk. Registration and account safety. The last thing you want is for a hacker to pinch all the email addresses and passwords of your members. I'm sure it happens sometimes, probably more often than we think, and you end up on spam lists as a result. But that is a concern. Protecting other people's rights? Well, you don't want people being defamed on your board, like the Mumsnet case. You don't want people's copyright being breached. You don't want people putting up a pirated torrent and saying, hey, check this out, because then your board is, well, you might want it, but some boards do, but it's something you need to be careful about. You can be criticised. You can be potentially sued. There's then a number of points on the Facebook statement of rights and responsibilities, as they call it, which relate to commercial things, which I'm not going to speak about just now. They say then in paragraph 13 they can amend the statement if they give notice. You don't have to agree to the amendment. And then they say any disputes will be governed by California law and heard in the California courts. And then right at the bottom in paragraph 18 they say this is an agreement between you and Facebook. They don't use the term contract. Usually when lawyers say agreement they think of a contract. Now it seems to me that the fact they haven't included an "I accept the terms and conditions" means that they know that it's probably not a contract. I'm speculating. They might well disagree with me. Why would they have something that looks like a contract when it probably isn't? Maybe, again I speculate, to deter people from suing them. It makes the whole case so complicated. They will say it's a contract, you will say it's not, and there's an argument. So it makes it more difficult to sue them. Now it seems to me very unlikely that any terms and conditions you put on your site will work as a contract if people aren't paying. Because you know it's a basic principle in the common law of a contract, in English law and US law. I'm principally concerned with English law here, that both sides have to give what lawyers call valuable consideration. Each side has to promise to give to the other side something valuable. And when people sign up for your discussion board, that doesn't happen, in my opinion. If you charge them £1 or $1 to sign up, then it probably has happened, and you can have a bit more control. But does it really help you? Because a lot of the people who may potentially sue you will be people who haven't signed up, who have just come to the board and have been defamed, people who are not your members. So all you can do, really, as far as I can see, is have a disclaimer telling people where you're coming from and the kind of care they need to take about the way they use your site. That disclaimer doesn't necessarily completely get you off the hook. It's good to put it somewhere where people can see it, and it gives you a little bit of protection. There's another disclaimer which Facebook use if you want to sign up for a page on Facebook. A page, in other words, a page for a community cause or a business and so on. It says create a page. And in this case, you do have to click and I agree to the face page's terms. And again, lawyers usually, when they see the word terms, they think contract. Face page's terms is, in my opinion, clearly not a contract. It's just a disclaimer. So it's well worth putting up some of these disclaimers, but they don't really protect you. How can you be safe about not being sued? The only way, really, is to keep a very close eye on your discussion board to see what people are posting and immediately deal with any problems in these areas we spoke about. And by all means, look for insurance. And really, that's the best I can offer. In the Mumsnet case, the defendants argue that there's no way they can follow every post on the discussion board and keep an eye on it. No, you need a lot of resources for that. And it's not yet clear whether that defence would have worked because it was settled out of court. But I have to tell you, you are exposed, but we always take risks in life, and if you can get insurance, great, and just be careful and keep an eye on things. And we'll return to some of the detailed aspects of defamation and so on and bullying in some future videos. So look forward to speaking to you again. Thank you.